Good afternoon. My name is Richard Lynch. I'm a director at FI 360. And first of all, I wanted to thank you for joining our webinar this afternoon. The title of the webinar, as you can see on the screen, is the final DOL Fiduciary Rule and putting investors first. Good afternoon. My name is Richard Lynch. I'm a director at FI 360, and I first of all want to thank you for joining our webinar this afternoon. The title of the webinar, the final DOL Fiduciary Rule and putting investors first. Topics I'd like to cover in the next 45 minutes or so are, first of all, give you an overview of the DOL's Fiduciary Rule, a rule that has been the topic of significant discussion and debate for well over a year now, and as we look at the chronology, you'll see actually going back to 2010. So we'll talk about that chronology first, then a little bit about what the rule hopes to accomplish, what's covered and what are the exclusions, what's in and what's out of the rule, and then also what is the definition of an investment fiduciary advisor as per this new rule. From there, for the overview piece, we will move to non-fiduciary communications, and then prohibited transaction exemptions. The most noteworthy there that we'll spend a fair amount of time talking about is the best interest contract exemption, sometimes known as the BIC exemption or BICE. And that I believe for many of you on the call, that's something that you probably have an interest in because it does have an impact on you. And then we'll finish with some key takeaways, some things based on our analysis so far of what we think you need to be keeping in mind as we move forward and head towards these implementation dates for the rule. So looking at the chronology first of all, as you can see by the slide, and here we actually go all the way back to 1975 when the original fiduciary rule was adopted. 1975, the year after ERISA was passed. So when the associated regulation was written that spoke to this rule and in particular this definition of fiduciary, that's when the five-part definition was in fact established, and we'll talk about that five-part definition in just a slide or two here, and we'll talk about how that has changed. But actually 75 is when that five-part definition got started. And then it was, it went along fine up until 2010. 2010 was when the first proposal to change this federal definition of fiduciary was introduced, and it was published by the DOL back then as a draft rule. Significant pushback from the industry. They didn't like the fact that they were going to make the change the definition of fiduciary, and by changing it, as we'll soon see, making it much more expansive, easier for the DOL to deem someone it being in a fiduciary rule than it currently is with the five-part definition. So there was significant pushback in 2010. The DOL pulled it back, and based on the comments they received then, tweaked it, changed it, considered other adjustments that they might make to it, and then re-proposed it last April in 2015. 2015, they had the comment period, and the comment letters that they received on the rule were extensive amount of comments. They had 4 days of hearings last August. They followed those hearings by another comment period, and then finished, in the fall, they began to digest all of that feedback that they were receiving, fall into winter, and then, as we all know, on the 6th of April last month, they reproposed. I'm sorry, they did not repropose. They published the final rule based on all the feedback they had received. Two significant deadlines that are in the final rule is from the standpoint of chronology. The first is April 10th of 2017, next year. That's the compliance deadline. That's the deadline where the new definition, the new federal definition of fiduciary will kick in. and the three-part definition will apply at that point, where up until then, we will still be under the current five-part definition. And again, I will talk about those in a bit more detail here in just a minute or so. And then also the second deadline where everything is takes effect and is required is January 1st of 2018, and that's when all of the requirements of the best interest contract exemption or BICE will need to be met. So the DOL, one thing we can tell by this chronology was that the DOL listened from the standpoint of feedback they've received to the second proposed rule, where the industry was saying, a lot in the industry was saying that the amount of time you're giving us to implement is too short. We need more time, and the DOL heard that and has extended the deadline accordingly. What does the rule hope to accomplish? This comment from the rulemaking itself, and I'm going to read it, although I don't typically do that first slide, but let me read this. Instead of ensuring that trusted advisors give prudent and unbiased advice in accordance with fiduciary norms, the current regulation, the current regulation being the regulation that is soon to change, erects a multi-part series of technical impediments to fiduciary responsibility. So what the DOL was really saying here was, with that five-part definition that we will look at momentarily, it was difficult for them to pin fiduciary status on somebody that they felt was behaving badly, and they were looking to take enforcement action against them. With the five-part definition, and and again, currently in place, one has to be deemed, meeting all five of those parts of the definition before you can pin that fiduciary status on them, and that's difficult to do. And the DOL candidly has been frustrated in their enforcement efforts, going after those that they thought were harming investors. So that's part of it. There's other reasons as well, but that's a large part of why they were looking to revise, update the definition, because they actually felt that the five-part definition, federal definition of fiduciary, was too restrictive and even not really in aligned with the intent of ERISA itself and what they were looking for from the standpoint of protecting the retirement plan participants. So that kind of gives you a flavor of some of the underlying background around what was driving the DOL to repropose this rule. I'm not going to go into all the details on this slide that I have here in front of you, but I did want to give you a sense of those types of plans or portfolios that are covered by the rule and those that are not. So in general, you can see the 401k ERISA plans are clearly covered. There is a large list of non-ERISA plans covered as well, and they're covered under the IRS code section 4975. Your MSAs, your covered ESAs, your health savings account. There are investments in the health savings account, so they will be covered by the new rule, all the way down through, for this middle section on the left-hand column, all the way down through your 403B plans, some of your 403B plans, and some of your 403B plans are in fact ERISA plans, but even for some of them that are not, they will be covered. And as you can see at the upper right-hand side on the right column, some 403B plans will not be covered. So the 403Bs in particular, you would need to do a little bit of work to determine, and probably legal counsel or compliance doing this, to determine whether or not it's covered by the new rule or not. IRAs, clearly covered, and this was a big deal. This was one area where a lot of pushback from the industry, those that felt that the DOL was overreaching by bringing the IRAs under this fiduciary umbrella that they had a purview over. So there was a lot of pushback on trying to prevent them from covering, from the rule from covering the IRAs as well, but that didn't happen, and it's clearly covered in the rule. And then on the right-hand side there, you can see some of the types of plans that are not covered in the rule, along with products, insurance products in particular, that don't have an investment component. So again, not dealing with investment, so the DOL is not concerned about fiduciary status of those that are providing advice on those particular products. So this slide, I think, bottom line, this slide is a good summary slide for you to use from the standpoint of, again, in general, what's covered by the rule and what is not. This is the 5-point definition I've been referring to. And again, this is the definition that is a result of the initial rule that was published in 1975. It's the current definition now. This will change once we get to April 10th of next year, 2017. So you see the 5 parts here. And all 5 is, from rendering investment advice, receiving compensation, all the way down through serving as the primary basis for the decision making. So the advice that you provide has to be the primary thing that's considered by the decision maker, the fiduciary, typically, in order for one who's providing the advice to be considered a fiduciary. So meeting all 5 of these and being able to demonstrate that somebody meets all 5 of these, again, has not been easy. In the new definition, 4 and 5 drop off. So, you will be deemed a fiduciary, if you're providing advice, if you provide the advice, if you receive compensation, if it's individualized, or in other words, if it's specific to a particular client that you engage with. If you're doing those first 3, then you're a fiduciary. You don't have to go any further. It does not have to be provided on a regular basis, and it does not have to be the primary piece of information that the fiduciary considers before they make their decision. Even without those 2, you're still going to be considered a fiduciary. So again, the net is being cast much more broadly. It's going to be much easier to deem one to be a fiduciary, from April 10th of next year moving forward. And my guess is that at least some of you on the call, where you may not be in a fiduciary role now, under the new definition, you will, and that's what has everybody interested and excited and concerned about the new rule. The fact that it's been finalized is probably an indication that it's going to be here to stay. One additional comment I'll make about that. Currently in Congress, they're working to try to stop the rule. It's likely, we don't know for sure, but it's likely that there will be a lawsuit trying to stop the rule as well. But the general comment I would make is, if I were to guess, I'm thinking the rule is going to be here to stay. And the reason I say that is because, DOL has been working on this since 2010. So they proposed it once, then they proposed it a second time. Based on the number of comments they've received and the letters, basically in letter form and in the hearings as well, and again, through 2 rounds of those, again, back in 2010 and 2015, and also, and probably maybe even more importantly, based on the changes that they made this time, from what was proposed last April to what is in the final rule, it's clear that they listened to the comments. They did make accommodations in certain areas. Some feel that they made too many accommodations. Others feel that they didn't make enough. And nobody that I've talked with is completely happy with the rule, which is an indication to me that they probably struck a pretty good balance between, trying to accommodate various factions of the industry, trying to accommodate different business models, trying to take into account the practical ramifications of what this rule is going to do with respect to those that have to implement. I don't think anybody would argue that it's perfect, but I think I think you would have to say that they did a fairly good job of trying to strike that balance, and it's because of that mainly that I'm thinking that the chances of it being turned around and stopped or overturned, again, my sense is it's probably pretty slim. Okay, so that's a definition of fiduciary. Now that leads to 2 clarifying questions. So what is investment advice, and who is an investment fiduciary advisor? With respect to the advice, the rule talks about 2 types of recommendations that would be considered advice. And the first one, advising on acquiring, holding, disposing of, or exchanging securities or other investment property, so advice on making specific investment decisions, or the whole rollover scenario, rolling over or transferring or distributing from a plan or an IRA to some other vehicle. That's the first piece. The second piece is recommendation as to the management of securities or other investment property. So the first piece here, more about the specific investments. The second piece, kind of at a higher, broader level, the actual management of the securities, and that's a little different than we've typically seen with respect to what we're calling investment advice. Advice itself, involves a call to action, and it has to be specific to the person receiving the advice. And it's that call to action along with the specificity that gives rise to the fiduciary accountability. In terms of trying to decide whether or not it is advice, the content, the context, and the presentation, all of those things are going to be important. Now, with respect to the management advice, as we look at the slide here, these are the things that are going to be considered management advice. Investment policies and strategies, and that's something that's probably going to be done at the firm level. They're making sure that the policies they have in place with respect to investment advice being provided, that the policies are aligned with the new rule, and strategies as well, from the standpoint of how we're going to approach clients and things that we're going to consider with respect to investments that would be recommended. Those again, both of those rise to the management level, and both of those would be considered providing advice. Portfolio composition would be considered a fiduciary act. Those of you that are constructing model portfolios, if you've been doing that in a way where you feel that you have been able to avoid fiduciary responsibility previously, it's going to be difficult to do that moving forward under the new rule. Selecting other investment advisors or managers. So if you're an advisor and you're assisting in the selection of the investment managers, that's going to be a fiduciary role. Even from the standpoint of the account arrangement, So if you're consulting a client and they're looking at bringing in an advisor, and you're having a discussion with them about whether or not it should be an independent advisor from an RIA firm, or whether their needs are better suited with a traditional broker from a brokerage firm, counseling a client on which way to go in that respect, that would be considered advice as well. And then again, the whole rollover transaction from the plan or from the IRAs into another investment vehicle of some type is going to be considered advice. And you can see 4 questions that we speak to here in those last 4 sub-bullet points. If you're providing advice on rollovers, and one comment I would make with respect to the rollovers is, this is one area that it's pretty clear from the rule, and even from all the back and forth that went on up to the rule through the proposals. The DOL is very concerned about rollovers, very concerned about making sure that participants or IRA holders aren't being taken advantage of. And so they want to make sure that they're getting all the information that they need before they make their decision. And that starts with whether or not I should roll, for example, whether or not I should roll out of my retirement plan at all. It may make sense to leave it right where it's at if I'm able to do that. If I'm not able to do that, then if a decision is made to roll it out, then how much to roll out, in what form, and to what destination. And so the questions that are going to be arising there are, okay, what type of vehicle am I rolling it into? Is it into another 401k plan as I move from one company to another? Is it into some type of an individual retirement account? Does the participant who I have been advising with their 401k, do they want to stick with me as their advisor, or do they want to consider other advisors that they may hire? So not only who's going to provide the advice, what IRAs are going to be, who's going to provide recommendations about which IRA. All of that has to be laid out for them so they can make an informed decision on what makes most sense for them. Because at the end of the day, with respect to these rollover transactions, is the advisor, whoever's providing the advice, is going to need to be able to demonstrate with documentation that advice was provided that was in their best interest. And so you would be obviously, well, maybe not obviously, but you would need to be able to demonstrate with that documentation that you provided them with all the possible information and all the potential decisions that they had, and then that they in fact made the decision based on what you presented to them. The definition of the fiduciary investment advisor per the new rule. So first of all, this person who provides it either advice directly or indirectly would be a fiduciary investment advisor if they represent or acknowledge that they're acting as a fiduciary. And it's pursuant to an agreement, an arrangement, or an understanding that is, again, individualized. It's specific to a particular client. The three words there are interesting: agreement, arrangement, or understanding. So it's clear from arrangement and understanding that it doesn't necessarily have to be in writing. You know, it could be a verbal agreement, and it's going to. You can see that it's going to be difficult for you to argue that you haven't crossed the fiduciary line in a lot of situations. And the advice is going to pertain to the advisability of investing in certain investments or with respect to management decisions regarding investments in a plan or some type of IRA investment property. So that's the fiduciary investment advisor definition per the new rule. Now, the next thing I'd like to do before I go into non-fiduciary communications and the prohibited transaction exemptions is to back up just for a minute and just to address some, what we feel are important big picture concepts. First of all, the bullet point at the top here, the rule is not just about conflicts. At FI 360, we talk about fiduciary responsibility all the time. That's what we do. And when I'm teaching class, I'm oftentimes, in the introduction section in particular, talking about the two primary fundamental fiduciary duties, the duty of loyalty and the duty of care. Now, this new rule coming out of the DOL was referred to as a conflicts of interest rule. And conflicts of interest pertains particularly to that duty of loyalty, where you're putting the client's best interest first, and by doing so, you're either avoiding conflicts, then that's the best case scenario, or if there are conflicts at play that cannot be avoided, then you're managing them in the client's best interest. You're being honest and forthright and candid with information. All of those things speak to the duty of loyalty, and again, conflicts of interest being a big part of that. But the rule also addresses the other fundamental fiduciary duty, the duty of care. And the duty of care really is all about prudence. It's about competence. It's about you being a professional and having the sufficient education, enough experience, and you're bringing your A game to the relationship in the sense that you're competent and providing a good level of service, a fiduciary level of service to them that meets their needs. The rule really addresses both of those fundamental fiduciary duties. The other thing that comes out of the rule clearly is, they key in on this term recommendation, and with respect to that, they say advice is a communication, again, that a person would reasonably view as a suggestion to take a particular course of action. So it's to a person, so it's specific. And if you're communicating to them in a way that they would reasonably view that as a suggestion to do this or do that, then you would be considered a fiduciary. Education and other communications without a specific call to action are non-fiduciary, and we'll get to those in next year, the non-fiduciary communications. There's actually 5 categories of those. In the proposed rule back in early 2015, they were known as carve-outs. Appraisals may be subject for fiduciary rulemaking later. So in the proposal last year, appraisals, valuations were considered fiduciary and were included in the rule. A lot of pushback on that, particularly from the insurance industry, and the DOL decided to pull appraisals out of the final rule they still think it's a fiduciary endeavor. Primarily, I believe, because the valuations that are done on property or investments, hard to value investments, are relied upon by those who are making investment decisions. So I think for that reason, primarily, the Department of Labor thinks that it is something that those that do it should be held to a fiduciary standard of care, but they're not going to do it in conjunction with this rule. They're going to revisit that later in a separate rulemaking effort. At least that's what they've indicated. Okay, so non-fiduciary communications. 5 categories of non-fiduciary communications, again, formerly known as carve-outs from the final rule. Platform providers, investment education, counterparty transactions, swaps and plan sponsor employees. Now, the swaps and the plan sponsor employees, let me talk about those briefly, and then we'll move to the top 3 with specific slides where I get into a bit more detail. And again, all of these are non-fiduciary communications, so if you're engaged in dealing with these types of transactions or with these types of parties or organizations, they would not be considered fiduciaries. In the case of a swap is a sophisticated transaction involving derivatives that are tied to things like interest rates, differentials in currencies, and it's transactions that typically take place between large lending institutions and larger organizations. So they're transactions where you have sophisticated parties on both sides. DOL is not concerned about ensuring that one or the other is a fiduciary in those rules, because the premise there being both parties know how this game is played and know how to play the game, so we don't need to worry about the swaps. And so they're considered a non-fiduciary communication. Plan sponsor employees is an interesting one. In this case, what the rule is saying is if you have a 401k plan within your organization, so it's internal to your organization, and you have an HR department, which most firms of larger firms have, and your HR employees are interacting with the employees of the participants with respect to their 401k accounts. Anything that the HR employees are doing in that regard is not going to be considered fiduciary or advice, because it's incidental to their role as an HR employee, and they don't want to chill the relationship between HR departments and the employees of the company. So those are going to be considered non-fiduciary communications. HR employees are not going to need to be worried about being deemed a fiduciary if someone happens to complain. Now, in the preamble to the rule, they also touch on this a little bit further, and they say, however, we would not view it as non-fiduciary communications if an HR department, based on this particular part of the rule, decides that they're going to hire individuals with financial expertise, like holding designations like the CFP or the CFA designations, bring them in to be part of the HR department where they're specifically going to be in a advisory type role, and that's why they were hired. That wouldn't fly. And even if an HR employee was paid up a certain amount, and then once the rule takes effect, they began to provide advice and were paid extra for the advice they were providing, that would violate the spirit of this carve-out or non-fiduciary communication as well. But if it's a traditional HR employee engaging the participants, helping them with their 401k accounts, even if they're providing advice under those circumstances and they're not being paid anything additional for it, they would not be considered fiduciaries. Now let's go to the top 3 and talk about those in a little bit more detail. Your platform providers, your record keepers, your TPAs, and others that make available platforms for the investment vehicles. So the record keepers, TPAs primarily, they have traditionally held themselves out as not being in a fiduciary role. We're just providing the platform upon which the fiduciaries can engage and make investment decisions that they're making and that we're not. So Non-fiduciary communications, if you're a platform provider, the platform provider must be independent of the plan fiduciary. They must state their intention under the new rule that they're not a fiduciary, and this is important. Third bullet point, they must also not become a functional fiduciary under the rule. So the platform providers, at least some of them under the new rule are going to need to be careful, because there are those who, record keepers, for example, who are engaging clients that are on the platform, and there's not an advisor in between them, and they're doing things like, and I've had calls at FI 360 along these lines. Here you have a record keeper with a platform. He's using the FI 360 toolkit, running the fiduciary score on mutual funds, and then is, narrowing down the mutual fund list based on those scores and providing that to a client that's on the platform. They would argue that they're not in a fiduciary role because they're providing some information on the funds, but they're not providing a specific recommendation. Record keepers or TPAs that are doing that, you're getting very close to it. In some cases, probably are crossing the line and becoming functional fiduciaries. So this is something that may be scrutinized a little more closely under the new rule. So it seems to me that the platform providers are going to need to evaluate the rule and make a decision. Or are we going to stay on this side of the fiduciary line and make sure we're not providing any type of advice, and then in some cases maybe even back away from some things that we may have been doing currently, or do we want to embrace this and are we okay with becoming fiduciaries, and we're going to take that additional step? It's something that the record keepers, the TPAs, the platform providers will need to decide what they want to do there. Couple more points on this. It's not limited by plan size as far as whether or not this is a non-fiduciary communication or not, and this isn't available. It wouldn't be considered a non-fiduciary communication if the platform provider was interacting directly with participants, beneficiaries, or the IRA account holders. They typically are not, so that typically wouldn't be an issue. But if they were, if they're dealing with the end investors, if you will, to that last bullet point, then all bets are off as far as whether or not they're crossing that fiduciary line or not. Investment of education, as it has been in the past, still considered a non-fiduciary communication. So you're not assuming a fiduciary role if you're just providing general investment education. And that general education would include things like descriptions of the investments or the plan alternatives, again, predicted without specific recommendations, general financial investment or retirement information, information about the asset allocation models, even interactive investment materials, fine, as long as it isn't getting specific. And this education can come from the plan sponsor, it can come from another fiduciary or others. The frequency, the form that it takes, the account types that are impacted, it doesn't matter. So the last bullet point, selecting and monitoring the education providers. Now that is a fiduciary obligation that would typically fall to the plan sponsor. Who they have doing this and ensuring that it's being done in a way that lines up with what was expected, and also lines up with the fact that the advice is not being provided would continue to be the obligation of the plan sponsor. Now, the limitations. In the proposed rule last April, they said that you can't get specific with respect to this education, or it's going to be considered advice. Even from the standpoint of, you can't mention a specific mutual fund, even if it's just being used just as an example to help clarify, the information that's being provided. A lot of pushback from the industry on that, because they felt that if you can't get specific to some extent, the education is just not going to be as meaningful to the participant. That was the fundamental complaint. So the DOL made accommodations here, and they said, okay, we're going to let you get specific if it's a designated investment alternative that's in the plan, or if it's an alternative, if the alternative is subject to oversight by the plan fiduciary, and the plan fiduciary is independent of the person who's developing or is marketing this investment alternative or this distribution option. So it's trying to make sure there's a arm's length relationship between what's being discussed as a possible investment way to go, that the plan fiduciary is making sure that there's objectivity from the standpoint of how that's being done. The models and the materials that are being used for the educational purposes identify all the comparable alternatives and also point to where you can get more information about the alternatives. So it's clear from this slide, bottom line, that you can get specific to a point, but if it's outside of some designated investment alternative in the plan, then the plan fiduciary needs to make sure that there's separation between who's saying that this looks like it's okay and unbiased, and that it's not the person that's providing the alternative, and that also there's enough information being provided on all alternatives so that the participants can make an informed decision. So again, bottom line, investment education still continues to be a non-fiduciary communication. And then the third category of the five, the counterparty transactions. These are sales to independent fiduciaries with financial expertise. So again, organizations that have expertise where the DOL is not concerned that they're going to be taken advantage of by somebody who's not being held to a fiduciary standard of care. So your banks, your insurance companies, your federal or state registered investment advisors, your broker-dealers, and then also, if it's a retirement plan and there's at least $50 million in assets under management or control, that would be considered a counterparty transaction. And again, larger plans, $50 million and up, there's, again, the premise being there's sufficient expertise within, internal expertise with the plan sponsor that they're not going to be taken advantage of by an advisor. And so the advice to those larger plans would not be considered fiduciary. Similar things here, though. The advisor would need to inform the fiduciary that they have no intent to provide impartial advice, that they do have conflicts, that they are biased. They have to have a reason to believe that whoever they're providing the advice to is an organization capable of expert evaluation. So again, we're speaking to these sophisticated investment advisory firms along with your larger plans. And again, this is not something that would be considered non-fiduciary if we're talking IRA account holders. With respect to your plans 50 million and under, moving forward under the new rule, you're going to be considered a fiduciary, and you're going to be considered a fiduciary, period. And that's really the way the new rule has shaken out. Okay, your prohibited transaction exemption. Three categories here: the best interest contract exemption, or BICE, and again, that's where I will spend most of my time in this section of the presentation. Principal transaction exemption as well, and then let me speak to the principal transaction exemption first, and then I'll talk to some of the existing PTEs before moving into BICE in particular. Principal transaction exemption is an exemption that has been out there prior to the new rule. It pertains to brokerage firms primarily that have securities in their own inventory, and at times they sell securities out of their own inventory to their clients. There's clearly a conflict there between selling to a client an inventory from securities from your own inventory. So this prohibited transaction exemption has historically been one where, the broker-dealer needs to make certain disclosures, ensure that the client that's being sold the security from their own inventory, that they're knowledgeable and that they have been provided information about the fact that there is a conflict. And this transaction is one that has been it's been put in place for a couple of years, and it's been renewed several times. What they did with this transaction exemption, well, as long with the other ones that were already out there, was they made sure that they were aligned as far as what had to be done and what the requirements were, that they were aligned with, or at least did not conflict with, requirements that are in the BICE or BIC exemption that are specifically in this rule. And the another existing PTE that I'll point to specifically is on the insurance side, and that's PTE 8424, and I'll talk about that in just a minute. So the best interest contract exemption, the key features for this exemption, and then, again, this one has gotten probably the most attention of anything in the rule. It's permitted, and it allows those who have variable or indirect compensation, typically brokers, insurance companies, indirect compensation, non-level compensation. It enables them to provide advice to these plans and IRA accounts where previously you were held to a fiduciary standard, and that was a prohibited transaction. So this is one area. Advice is an area where the rule actually, you could argue, is lowering the fiduciary standard because we're allowing non-level or variable and indirect compensation. But advice is also, and as you will see as we go along here, is putting a lot of things in place that are required from the standpoint of compliance and documentation to ensure that those who have non-level compensation are going to be acting as fiduciaries in the client's best interest, if not on their own volition, but because of the requirements we place on them from a standpoint of ways that they need to demonstrate that in fact is happening. Advice allows for binding arbitration for the IRA holders. For your plans, there's a separate course of action through the courts if one wants to complain. Class action suits will be available if there's systemic abuse across many clients. And this also covers, it does cover advice to the participants, to the IRA holders, and again to your small plans. In the case, for the purposes of this rule, those would be the plans under $50 million in assets. One somewhat of a surprise with respect to PTE 8424 was, prior to the final rule, the fixed annuities, including the index annuities, were not included in the rule. The variable annuities were. Now, in the final rule, variable annuities along with equity index annuities are included and would fall under this, under BICE or the best interest contract exemption. It's only the fixed annuities that would be covered by prohibited transaction exemption 8424, and the difference, the primary difference between those two from a practical standpoint is the requirements that you need to meet under 8424 are not as onerous as you need to meet under BICE. So the fact that the equity index annuities are now under BICE has those that deal with those groaning because they're going to need to meet a more stringent compliance requirement under BICE than they would have had to if it continued under PTE 8424. These are the BICE requirements. You need to acknowledge fiduciary status. And as a fiduciary, you need to adhere to impartial conduct standards. That's traditional fiduciary. It always has been. So you're providing prudent advice. You're charging only reasonable compensation. You're avoiding misleading statements that could confuse. And again, under BICE, you're going to need to enter into a contract with the participant, the beneficiary, or the IRA holder, a legal contract that will give them recourse to take action against you if they think you've done something wrong. As you move up to the firm level, the firm, again, and I mentioned this earlier, the firm will need to implement policies and procedures that are reasonably and prudently designed to prevent violations. So from a risk management standpoint, they're adjusting their policies and procedures to accommodate this BICE arrangement, assuming the firm has made the decision to operate under BICE. And the policies and procedures can be viewed and deemed that, in fact, that's what they're doing. Refraining from sales incentives that would cause a rep, an agent, an advisor to act in ways that are contrary to these impartial conduct standards. So if you're providing incentives, sales incentives to sell, proprietary products from the firm that could impact an advisor or a rep's judgment from the standpoint of providing impartial advice that's in the client's best interest, because they're concerned about they're trying to meet the sales goals based on the incentives, that's going to be problematic. And so there will probably be, in general, movement away from sales incentives that will do something like that. Again, disclosing fees, compensation, conflicts of interest. For the plans, that's not new, and that's fiduciary, and that has been in place for the plans since 4AB2 was passed. Rule 4AB2 was passed in 2012. This will be a little different for the IRAs, and again, that will be new for those that are only operating with the IRAs. The last bullet point, notifying the DOL. So the firm needs to make a decision, are we going to operate under BICE or not? And what I mean by that is the firms are wrestling with, we speak, and I've spoken to and presented to a number of firms since the rule was passed early April. But your brokerage firms, your insurance companies in particular, they need to decide, for the fiduciary accounts, which includes plans, but now also includes your IRAs. And your IRAs that really creates a bridge from the retirement plan world where we have traditionally thought about fiduciary over into the high net worth market in a big way, because most retail clients probably have an IRA or two or three. So fiduciary is moving over there in a big way, and so the firms are going to need to decide, do we want to embrace the fiduciary role, and are we concerned enough about the onerous requirements of BICE that we're going to, for those fiduciary accounts, are we going to, move from indirect and non-variable, variable comp, indirect compensation to level comp, and remove the conflicts, if you will, so we don't have to deal with BICE? Or do we think that we don't need to do that? And if we don't need to do that, then we need to make sure that we're doing the things that are on this list here to make sure we're aligned with implementing BICE properly. And if they're going to be working on a BICE, which I'm guessing probably most that have the conflicts will, then the firm needs to notify the Department of Labor that that's in fact the decision that they have made. Some limitations under BICE: proprietary products are subject to findings. Proprietary products still allowed, so firms can still sell proprietary products. But again, they're going to need to justify in written documentation why it still makes sense to sell their own proprietary products to their clients. Again, subject to impartial conduct standards, the fiduciary standards. So, it continues to get tougher, I believe, to articulate and argue that it's in the client's best interest. So we will probably see a movement away from proprietary products as we go forward, but time will tell. Have to disclose the conflicts as they produce this finding, and the compensation has to be reasonable. So they're going to have to demonstrate in documentation that all those things, all of those standards are being met with respect to their own proprietary products. And if they can, not an issue. If they can't, then they may have to do they may have to consider no longer offering up a proprietary product, and some will probably decide to do that. The complex illiquid products in the proposed rule last year, those were off the table. They again concerned about a participant IRA holder or beneficiary being sold a product that just was not suitable to them, too complicated, too expensive, too illiquid, etc. So they basically said you can't sell those products in these types of investment vehicles. But they backed off that. They got a lot of pushback from the industry. So again, to their credit, they backed off and said, we're not going to put any limitations in place, but we are going to, whatever you recommend to the end client is going to be subject to the prudent standard which comes from ERISA, and that's the fiduciary standard. As long as that standard is met, then whatever you recommend is fine. And that candidly, I think that makes sense. That makes sense. In certain situations, maybe a highly complex hedge fund makes sense for this investment retirement vehicle. It wouldn't be common, but maybe in certain cases it makes sense. So the DOL has given the advisors some flexibility there on what they want to do. Last point, the advisors that have discretion, advisors that take discretion are not going to be, advice is not going to be available to them. So in other words, you're not going to be able to get an exemption if you're engaged as an advisor with discretion and you want to continue with non-level comp, indirect compensation that have the inherent conflicts. If you're going to take discretion, you're going to have to remove those conflicts and operate under what has been the traditional ERISA fiduciary standard. We get several questions, or I've gotten several questions regarding these grandfathering provisions, with respect to, clients that you had prior to the rule, you have provided advice on investments, they're in those investments now, there's variable comp involved, you may be getting some trails off of those investments. All of those prior arrangements can continue even after the rule, even after April 10th of next year. Now they will be subject to ERISA's reasonable compensation standard, but you're going to be allowed to continue those until you do something to that account, and then once you do something to that account that changes things, then you're going to need to comply with the new rule. This level fee exemption, this is one, some refer to this as BIC light or BICE light. And this is a case where you're an advisor, your compensation structure is levelized. You're providing advice to a 401k participant, and they leave the company. You have a conversation about rolling it out of the plan and into an IRA. You go through that whole process that we described earlier. The decision is made to roll it out. And when you move it into an IRA, your compensation is level there as well. However, your compensation with the IRA is higher than it was for the 401k. That's going to be allowed, and that was another accommodation that the DOL made based on, recommendations or suggestions from the industry. FI 360 in our letter, we suggested that we thought as long as it was going level to level, there would be an expectation that the fee would go up as you move into the IRA. So the DOL is okay with that. You're still going to need to acknowledge fiduciary status. You're still subject to these impartial conduct standards, the fiduciary standard. And again, here's the key, and you need to document reasons why what you recommended was in the best interest of the client. And this is the one area where I believe the advisors that have had level fee in place for a while now, that probably in a lot of ways are not going to be significantly impacted by this rule. This is probably one area where you may need to tighten things up a bit with respect to the rollover transactions, just ensuring that you're doing a good enough job of documenting, that what you advise was in the client's best interest. So just last couple slides here, and then I'm going to wrap up. With respect to the BICE blueprint, so for those of you that are going to be operating under BICE, you're going to need to carefully design your engagement agreements for each client, and you're covering, the scope, the service expectations, and the limitations. Again, these impartial conduct standards are going to apply, serving the client's best interest, reasonable compensation, no risk misrepresentations, things being done at the firm level with respect to the compliance manual and the policies and procedures that are lined up to ensure, from a risk management standpoint, that you're going to be incentivized to be providing advice in a scenario where you've got a conflicted business model. The procedures are going to be set up in a way that encourages, ensures that objective advice in their best interest is being provided. You're going to want to mitigate these conflicts of interest under BICE, because you've got them, and that's why you're under BICE. Again, disclosing the fees, compensation, conflicts of interest, and again, I can't emphasize enough the need for thorough documentation. And then finally, the key takeaways. It's not just about the conflicts. Care and prudence are essential. We spoke to those two fundamental fiduciary duties of loyalty and care, and both of those apply in a big way with respect to the new rule. Communication is suggesting a particular course of action, and that's what's going to be evaluating that as a communication is going to be what's going to deem you to be a fiduciary. Bottom line. I already made the comment that those of you that have routinely operated on as level fee fiduciaries are not going to be greatly impacted. Tightening up the documentation for the IRA rollovers is probably the one area that I can think of where some work may need to be done. Price is a significant burden. The DOL would prefer, I believe, that everybody move to a level comp, unconflicted model. Practically speaking, that's not going to happen, but it's a significant burden because they want to make sure that where there are conflicts, that doesn't cause one to inadvertently provide advice that's not in the client's best interest. I do believe the products will change. Compensation removed in some cases. I've heard mutual fund companies talking about removing the 12B1 fees because they're concerned that advisors are going to avoid them because of the potential of non-level comp and what the complications that's going to cause. So the products will be impacted. The quality improved from the standpoint of, again, if there's more scrutiny being placed on advisors in general that are being held to a fiduciary standard where you have to demonstrate that you're providing advice that's in their best interest, that will drive a higher level of due diligence, and that will drive ultimately better quality. Bottom line, and some of the trend here to some extent has already started, but moving forward, probably continue to see fewer advisors, everybody being fiduciaries, or certainly many, many more being fiduciaries than that was held to that standard in the past, but also all, I believe, competing as professionals. And I guess the final comment I would make is, I do believe that there is significant opportunity with this rule. It's going to be painful for certain firms, and if for no other reason because changes have to be made. But I believe that it will help to continue to raise the bar in the industry from the standpoint of the professionalism of the advice that's being provided. And at the end of the day, I think that's going to help all firms. And so even though in the case where there may be some short-term pain, I think all in all, the industry will benefit from the changes that come from this rule. And it'll just be interesting to see how that plays out. That's where I'm going to stop for today. I want to thank all of you for joining the webinar. I hope this was informative, and best of luck for you and your firms as you begin to make the decisions with respect to how best to implement the final rule. Thank you, and have a good day.